Next, we are pleased to welcome Rabbi Shlomo Weissman, Director of the Beth Din of America, who will be speaking on secular law and equity in Beth Din decisions.
Thank you. Thank you to the organizers and to all the panelists. Rabbinical courts, or Batei Din, are frequently called upon not only to mediate, but to actually arbitrate and issue binding decisions in commercial cases. It's ironic that the two most common legal doctrines that we use when doing so are methods that pull away from Jewish law. First, our dayanim, our arbitrators, commonly look to minhag hasochrim, or local law or custom that can be at odds with Jewish law as the governing law of a case. And two, we'll often use a concept known as pshara hakrova ladin. Pshara literally means compromise, like the kind you'd find in a mutually agreed upon settlement. The Talmud loves compromises because they're peaceful. But in this context, pshara means something closer to common law equity, an adjustment or a correction that arbitrators will incorporate into their ruling to avoid a harsh letter of the law outcome. Why are these two things, adoption of local law and equitable assessments, so ubiquitous in rabbinical court rulings? It's because they solve a problem inherent in religious arbitration. One of the necessary elements of a functioning legal system, we know, is adaptability. Legislatures react to changing markets and changing societies by passing laws that speak to the moment. Courts roll with the times. Now, in the very old days, Jews had a commonwealth, and so things went well. It was easy then. Even through the Middle Ages, and as late as the 1700s, Jews lived in closed and autonomous communities. There was a structure of legal authority. Communities could band together and they could pass enactments that addressed pressing business and other concerns. But you could see the problem coming. The French Revolution and Napoleon and emancipation changed everything, starting in Western Europe, and then over the next 100 years, slowly rolling through Eastern Europe as well. Ghetto walls started to come down. Today, even when both the party and the counterparty are perhaps both religiously observant Jews, they'll conduct their business affairs utilizing tools of secular society, limited liability companies, joint venture agreements, employment agreements, contracts of every variety. So how on earth, how do you use a religious legal system that's untethered from any specific time or place or society or market, no hierarchy, no legislature, no centralized court system? If a Beit Din simply overlays classical Jewish law to modern transactions in every case, you're going to get unexpected and inequitable results. Every veil will be pierced. Every futures contract will be thrown out as overly speculative. Can a contemporary Beit Din then deliver just outcomes in complex business cases and at the same time faithfully apply Jewish law? Thankfully, our ancient system of law, with its reputation, perhaps rightfully earned, perhaps not, of rigidity and formalism, is really actually very versatile. Minhag hasochrim, the idea of incorporating local law, is rooted in contract theory, where we can reasonably presume that parties entered into a transaction with the expectation that marketplace norms and local law will govern their dealings. Jewish law will respect that agreement. And when it comes to pshara or equity, there's a fine line, of course, between equity and judicial freewheeling, but properly limited, equity is an important part of rabbinic dispute resolution. These and other ancient methods are valuable tools in a Beit Din's arsenal. We use them regularly to ensure regularity, equity, and justice in the cases that we decide.